So after a morning that was filled with such personal significance, we'll begin our afternoon sessions with a panel that for me has professional significance, moderated by Dr. Roy Schondorf, the head of International Dispute Resolution at Herzog and the former Deputy Attorney General for International Law. And the panelists include Dr. Gilad Noam, the current Deputy Attorney General for International Law, responsible for heading Israel's challenges at the ICC, ICJ, and elsewhere. Lord David Wolfson, KC, who we had the pleasure of hearing from and has been introduced. Dr. Eran Shamir-Borer, the Director at the Center for Security and Democracy at the Israel Democracy Institute, and my former commander as the head of the International Law Department, and Colonel Sharon Zagagi, the former Chief Military Prosecutor and head of the Dinah project. Thank you.
Well, hello everyone, good afternoon. It's really a pleasure to welcome you all to this panel that I think is quite a unique panel, mostly because of the really exceptional speakers that we have here with us today, representing not only quality of and professional strength, but also I think a diverse set of opinions and institutional perspectives that could help us develop somewhat further our thinking on Israel and the international tribunals. The challenges that Israel is facing in the legal arena internationally and in international tribunals specifically is of special importance to our organization. Mayor highlighted it yesterday in some of the things he said. The organization sees itself as the legal arm, or at least a legal arm of the Jewish people, and in that context tries to supplement the record in cases where, for example, it is less convenient for the Israeli government to present, to participate or present arguments. We believe it is very important that judges in the different institutions will also be exposed to the perspective of, or to some of the legal arguments that they're viewed or seen from the perspective of the Jewish people. Now, obviously that's a challenge because, for the Jewish people there are many different points of view, and we try to always do things in a professional manner. And the participants here could, take a look, if you want, in the recent issue of Justice that was distributed in the materials for this conference, and see one example of our submission to the International Court of Justice that, among other things, highlights the legal framework and arguments relating to the future of the West Bank, which, in my view, is perhaps the first time that such legal arguments are being made in a formal context before international tribunals. So perhaps without further ado, I will kick off the panel, and maybe the first question will be to you, Gilad. Gilad is the Deputy Attorney General of Israel for International Law. And I want to ask you, Gilad, I think many here in the audience, many of us feel that Israel is not always or not at all treated fairly in international fora and specifically in international tribunals. To what extent do you really think this is the case? And perhaps maybe you can give us some examples of your experience, our shared experience as Israelis, that highlights some of these, that highlight some cases where we actually could feel that we're not treated fairly in international institutions.
Thank you, Roy. First, let me say how meaningful it is for me to speak here in Warsaw. This place for me is a reminder for both the unimaginable atrocities and the resilience of the Jewish people. This is part of our shared collective memory.
Sorry, I jumped the gun before, with the questions before we wanted to actually start this panel with just a short presentation, just highlighting the different arenas and the different legal cases that Israel is facing, and Eran agreed to do that. Eran Shamir-Borer is the head of the Center for National Security and Democracy at the INSS, at the, Israel Democracy Institute.
Wow. It's the second time Roy is trying to offend me. I mean, first he neglected my presentation, and now he's...
Okay. Sorry for that, Eran. So let's start with that and then turn to Gilad.
Okay. So maybe at the risk of being a bit superficial, what I was hoping to do was to really provide a very brief overview of the various legal proceedings taking place overseas nowadays relating to the conflict in Israel, like really taking stock with very broad strokes of brush. And I think it helps to understand the volume, the intensity, and the nature of the proceedings, the way they take place, I think in an unprecedented way that any other country had to experience in modern history. And obviously, it's a discussion that has relevance to the Israeli context, but I think much broader than that. Now, the Israeli context is, I think, unique. It's unique in the sense of the motivation of the various actors trying to bring Israelis and Israel before the court. I think also the impact of such proceedings on Israel is different than other countries. But at the very same time, I think it's also a very important opportunity for a serious discussion about some of these institutions, and also in the context of other states. I think there is something manifestly problematic with some of these institutions, some of the proceedings that they apply, and I think this also presents an opportunity to discuss it. And we already starting to see, some level of pushback by other states. We've learned, for instance, that Hungary hosted the Israeli Prime Minister despite the fact that the arrest warrants against him issued by the International Criminal Court. We hear of Hungary and other states already declaring that they want to step back and leave the court. And also, we see the U.S. response, for instance, a very, I would say, not a conventional diplomatic response, taking sanctions against the institution and individuals within the institution. And another benefit, I think, of trying to take a broad look of the current situation is also to try to assess this as a phenomena, to see how different actors, sometimes the same actors, are operating in different arenas, and also assess the networking, the connections, formal but very often also informal, between the various proceedings. Sometimes, NGOs operating in different sites. Sometimes a decision being taken in The Hague is taken into consideration when a district court in the US, for instance, needs to make a decision in the context of Israel. It presents a serious challenge to Israel. It presents a serious challenge to a state that has to try to manage several legal arenas at the same time. Imagine, I know some of you are criminal lawyers, defense lawyers. When you're a defense lawyer, you try not to surrender your narrative, your facts, if you don't have to, right? But what do you do if you have to defend a genocide case in the International Court of Justice? And you need to make various legal statements, legal argumentations, speaking legal positions on different aspects, and also present the fact. But at the very same time, you also need to adopt a state of mind of a defense lawyer in the International Criminal Court, not far from there, right? So for a state, it's very hard to manage this way, and I think especially for democracies. Because in democracies, we have transparency, we have sometimes criminal proceedings against our own nationals, and very often, by doing this, you might find yourself also exposing yourself to greater legal risks in foreign jurisdiction. So let's try to go on a very quick journey. Buckle up. We're going to start in the Hague. So in The Hague, as you know, we have two courts. We're going to start with the International Court of Justice. That's the UN highest legal instance, the highest legal instance of the UN system. It decides contentious cases between states, but also provides advisory opinions to various organs of the UN. Okay, so this is the ICJ. Over the past 2 years only, Israel has been directly at the ICJ 3 times and still is. One of them is a genocide case. The case the application submitted by South Africa against the state of Israel for violation of the Genocide Convention. Now, when you're in the court, and you may see some familiar faces here, right? Gilad, sitting right under your picture. Ben Wallhouse, our MC. And when you're in the court, it's almost, you feel, serious lawyers feel it's almost a preposterous proceedings, right? Because it's a case relating to the armed conflict between Israel and Hamas, but Hamas is not there, right? The court has no jurisdiction over Hamas. Hamas is not party to the Genocide Convention, and this is a court that has an authority to issue orders ordering Israel to cease the hostilities, to cease the fire in the Gaza Strip. That's what actually the South Africans were seeking when they initiated these proceedings. And procedurally wise, the threshold in order to have the court issue such orders is quite low, okay? But Hamas is not there. So the court could order Israel to halt its fire in Gaza and, maybe pay some lip service to Hamas. You need to put down your arms and release Israeli hostages. And also, when you enter the court, when you're Israel entering the court, before even entering the hall, you can't even win the case. You can't even start convincing almost half of the judges on the panel because they're coming from states, with sometimes hostility towards Israel. Many of the judges are coming from states without, any tradition of judicial independence. When you're speaking before the court, and you know that one of the judges on the panel is the Lebanese judge, Noam, and we've known him because he was a diplomat, a very anti-Israeli diplomat for Lebanon for many years. He's not even going to raise his pinky toe in favor of Israel, even if Israel makes very convincing legal arguments. And sure thing, we know where Noam is today, right? He jumped straight from the position of the president of the court to be the prime minister of Lebanon nowadays, okay? So it's very challenging, to manage before the court, and sometimes the legalization of politics becomes the politicization of justice. But still, Israel appeared before the court, and I think quite impressively, and managed, very successfully to push back against the attempt to issue orders issued by the court ordering Israel to cease the fire. The court did issue a few other interim orders. The status of the case, it's still pending before the court. Israel is due to submit its memorial in March next year, and we'll see what the court will decide by then. I would mention, beyond being, just a professional task, Ben and myself were part of the defense team to the court as part of our reserve service at the IDF International Law Department. It was also a very, I would say, emotional and national experience. We knew that when we were in the court, even if we wouldn't be able to convince some of the judges on the panel, we were speaking also to the people in Israel. We were also speaking to you, world jury, trying to remind ourselves who we are, and also, to answer some of the harsh critique leveled against Israel. It was also very emotional because Israel chose to nominate as an ad hoc judge to the court Justice Aharon Barak. And being in the courtroom and knowing Barak's survival story during the Holocaust, to see this amazing person who dedicated his life to trying to strike the right balance between ensuring Israel's security and democracy, sitting at a genocide case against the Jewish state. So once again, the victims are becoming, to be blamed as the perpetrators. And we also traveled to The Hague with families of hostages. You could see the father of Omri Meiran. It's actually the first time that I show this picture after Omri Meiran had already been released from captivity. Now, beyond these two, the genocide case I would just mention, the court already issued 2 advisory opinions at the request of the General Assembly over the past 2 years. One of July last year determined that Israel's presence, military and civilian presence in the West Bank is unlawful. So the Israeli presence unlawful, and Israel needs to evacuate its presence from the West Bank as soon as possible. And this is a decision made after October 7. Okay, so Israel is expected to withdraw from the West Bank without any security arrangements instilled in order to ensure the safety of Israeli citizens. And the other advisory opinion was just handed a few weeks ago. It looked into Israel's legality of the change of policy of Israel with respect to UNRWA and the humanitarian obligations of Israel in the, primarily in the Gaza Strip. And again, the court decided that Israel is violating in violation of the law. So these are, that's the ICJ. Let's move very quickly to another arena in The Hague, the International Criminal Court. I remind ourselves that's a court that Israel did not join, but it's a criminal court. Okay, it has jurisdiction with respect to individuals, military commanders, people in the political echelon, for a list of a whole list of international crimes, war crimes, crimes against humanity, and genocide as well. And this court has been running a criminal investigation in the context of the Israeli-Palestinian conflict for quite a number of years now, but they invested a lot of resources into this investigation after the outbreak of the war in Gaza. And then in May last year, Karim Khan, then the prosecutor of the court, is dropping no less than an unconventional bomb. He's declaring and surprising Israel as well, because on the very same day a delegation from the prosecutor's office was supposed to land in Israel, he's announcing that he decided to request the court to issue arrest warrants against Israeli Prime Minister and the then Prime Minister of Defense. The first time ever that the prosecutor requests arrest warrants against the heads of a democratic state, and a state which is not a member of the court. And sure thing, a few months later, a panel of 3 judges confirmed the request and arrest warrants were issued. Okay? There's a whole, a whole list of suspicion and offenses that the prosecutor mentions. Israel is not privy of the application itself. Israel is not aware of the factual metrics, of the legal arguments that the prosecutor present to the judges. And Israel did not receive the full copy of the judge's decision. It's all privileged, only a snippet of it. But the fact remains today that there are arrest warrants pending against Israeli Prime Minister and the former Minister of Defense. All the green states that you see on the globe map here, over 120 members of the court are allegedly under an obligation to surrender those with arrest warrants against their name to the court in The Hague if they step foot in the court. Now, as I mentioned, we do see some pushback. We do hear some argumentations that maybe, at least the Prime Minister enjoys immunity, but that's a serious thing. And beyond, just the risk for Israeli officials that they could be arrested, you can imagine what could be the impact on other arenas as well. So that's where we are today. You may recall, that when the prosecutor was making the announcement of his intention to request for arrest warrant, he was trying to create some kind of moral equivalence, I would say, between Israel and Hamas. Because he waited so long in order to also request the court to issue arrest warrants against Hamas leaders. Okay, even though Hamas was very obvious about their intentions, they documented their crimes. Obviously, there is no functioning legal system that would investigate and look into the allegations against Hamas, but it took the prosecutor in his office quite a long time, and he decided to choose on the same sheet of paper, on the same date, to request arrest warrants against leaders of both sides of the conflict. You may know that Israel, killed the whole 3 of them. I would say at least the court did not blame us for obstructing justice, for doing so. But this is really outrageous. At the end of the day, 2 years after October 7, the fact remains that there are only arrest warrants against Israeli leaders and none against Hamas or any other Palestinian leader. I want to move very fast to domestic courts. And here I would differentiate between two types of proceedings that we've seen. And again, the volume, the intensity is unprecedented. One type is attempts by many individuals, NGOs, and others to have arrest warrants and criminal proceedings initiated against Israeli officials, soldiers, commanders, politicians. There are NGOs, such as the one we see here from their social media, NGOs that's what they do for their living. They wake up in the morning, they try to mine social media for allegedly incriminating information against Israelis, and then once they have information that those Israelis are planning to visit this state or another, and I'm speaking about the entire world, from Brazil to Thailand, okay? Then they try to engage with local law enforcement authorities and have investigations and arrest warrants issued. Unfortunately, IDF soldiers were not very disciplined, in keeping information very discreet. So they made the life of these organizations very easy. I am happy to say that so far, full-fledged criminal investigations are taking place in very few countries, okay? In South Africa, in Belgium, in Poland, but not only many other countries. What we see now is not that the attempts are focusing not just on allegations of violations of the laws of armed conflict, but also for the mere service in the IDF. But the fact is that nowadays we have people who served in the IDF as lone soldiers, for instance, of South African origin, who just can't visit their families nowadays because they're facing the risk of being arrested. Another type of proceedings that we've seen in this conflict is the attempts to have various governments and courts in different countries limit the sales of arms, the export of arms to Israel. In some places, we see campaigns in many countries, and bear in mind, these countries are generally close allies of Israel, right? We buy weapons to sustain the IDF from our allies. So sometimes, there are pressures exerted on local foreign offices, and eventually they make a political decision to limit or to stop altogether the sales of arms. And sometimes those local authorities are being challenged before local courts. And we've had proceedings in the UK and in the US and in France and in Germany and in a number of other countries. And in some places they have been successful. Okay, so the Supreme Court in the Netherlands already early last year decided not to ban the sales of components for F-35s to Israel. Just recently, a higher instance decided to overturn the decision. But this is, again, a very significant phenomena that really has a concrete impact, on the ability of the IDF to conduct itself effectively on the battlefield. And last thing I would just mention, that there are also various proceedings and processes that are not purely legal, primarily within the UN system, but they really have bearings on what's happening in other more legal jurisdictions. So, for instance, when the Commission of Inquiry of the Human Rights Council issues its report, one of many reports dealing with the responsibility of Israel in the current war on genocide, obviously that's like the dossier, okay? That's like the evidence file that other jurisdictions around the world could use. That's also, even though formally it's not binding or anything like this, it does have an impact. So that's for now, and I'm getting to IC. Thank you.
Thank you. Thank you, Eran. I think this gives us a sense of the scope and perhaps the significance of the challenge. And with that background in mind, I want to turn back to you, Gilad, that with the hope that you can share with us that, again, maybe having seen that, one could argue, these are international institutions that, apply legal standards, and so what's the problem? If Israel has, has something to argue, it can argue it and defend itself. what is it that makes us feel, what is it in the experience that we have there so far that makes us feel maybe that Israel is not treated fairly by these institutions?
Okay, so thanks, Eran, for setting the stage. I think now maybe you can feel a little bit empathy for what we have to deal with. First of all, yes, we do feel that there is a bias against Israel. I would say that for decades, for a long time, Israel has been very much skeptic about international courts, about international judicial bodies. Part of it is, of course, the fear of getting an unfair treatment. I think part of it is also a more, and we should say that, a more principled approach that views negotiations, mutually agreed solutions as preferable to legal proceedings in general. I think it resonates perhaps with things that we heard yesterday from Lord Wolfson. Now, as you can see, in recent years, yes, Israel do participate or taking a more active approach towards international courts. My personal opinion is that it would be wrong to categorically think that participation is always bad for Israel or negative for Israel. I can elaborate about that later. I do think that even in the toughest stages, Israel, or at least it should be considered that Israel should be heard. Now, you ask for examples, Roy, about bias. Yes, there is bias. And later we can talk about also the reasons for that and what we think about that. So maybe two prominent examples. One, Eran mentioned the ICC, the International Criminal Court. Israel has a very clear and quite simple position why the ICC lacks jurisdiction. I think it's not the place for me now to describe the legal position in detail, but I'll say very generally, the position is based upon the fact that Israel is not a state party to the ICC. So how come the ICC has jurisdiction? Well, first of all, you should know that the ICC does not have jurisdiction over many situations around the world. You saw the map that Eran showed before. So there are atrocities in Syria, there are atrocities in Iraq, against the Yazidis, for example, many other examples around the world. And maybe, unfortunately, but the ICC does not have jurisdiction because these are not state parties. Here, the claim is that because the Palestinians delegated jurisdiction to the court has jurisdiction. Israel denies that because there is no sovereign Palestinian state. Even if you create a kind of a imaginary or you're saying that the Palestinian Authority can in some way be considered a state in that respect, still you don't have a sovereign territory. We know that the territory is the subject to a long dispute between Israel and the Palestinians. So the sovereignty is undetermined with regard to this territory. And even if you think that this dispute in some, again, distorted way was decided in favor of the Palestinian side, and they can approach the court and say, well, this is our territory, the territory of the Palestinian state, and we can delegate jurisdiction. We're speaking about an international criminal court. Delegating a criminal jurisdiction to an international criminal court requires that the entity, the legal entity that delegates that, has that authority. That's a very basic principle of law. You cannot delegate, you cannot give something that you don't have. And the Palestinians do not have criminal jurisdiction over Israeli settlements, over Israelis personally. Whenever, even if an Israeli commits an offense within Area A or Area B. That's, in essence, the claim. Now, within the international legal discourse, all kinds of lawyers try to develop all kinds of opposing theories, very, very complicated. By the way, if they are so complicated or so novel, we think that the result should be no jurisdiction, right? We're speaking about an international criminal court. You can't go, and trying to find the creative solutions for that. Again, maybe we should strive to do it in Syria, in Iraq, maybe in other places. But it was never done, in other places. But let's speak about the ICC and about the bias. At least we expected, that our arguments will be considered, maybe together with other, opposing views, and be considered on their merits. We began back when Roy was in office in 2019 by presenting indirectly our position to the court. We published the Attorney General position with regard to the lack of jurisdiction of the ICC. Eventually, in 2021, we got a majority opinion of 2 against 1. One judge gave a very, very detailed opinion, more than 100 pages, analyzing the situation, reaching the conclusion that the ICC does not have jurisdiction over Israelis. The other 2 judges didn't even address in detail many of the arguments. They left the question to be determined later. They said, well, we can say because of the political situation, because of decisions that were made in the United Nations, that there is a Palestinian state for the purposes of the ICC, that there is a Palestinian territory encompasses the West Bank, Gaza, and East Jerusalem for the purposes of the ICC. And what about the issue of delegation of jurisdiction? Well, that's difficult. Well, let's leave it for a decision maybe down the road. Okay? Now, as Eran described, we reached a point in which the prosecutor asks the judges for arrest warrants. Indeed, a very, very dramatic event. And the issue of jurisdiction, at least from our perspective, is undecided. And it is expected from the judges to decide this issue. Now, we are directly approaching the court, and we raise the jurisdictional arguments. By the way, we were not alone. Other states also supported us in these arguments. And what was the result? The arrest warrants were issued a year ago. And in parallel to that, we received a decision on jurisdiction that says that Israel lacks standing. They didn't even consider the arguments on the merits. And I remind you, since 2021, the issue remained undecided. There are complicated legal issues to be determined. Because they are so complicated, again, we think that the result should be clearly no jurisdiction. It's not the job of the court to resolve, such issues according to all kinds of novel theories. The situation on the ground is very simple. The Palestinian cannot delegate jurisdiction to the court. There is no sovereign Palestinian state. Any other statement, maybe a wishful thinking, maybe a political thinking, but it is not related to the reality on the ground. That's a clear bias from our perspective. We appealed this decision. Again, we're taking an active role now. Fortunately, the appeal succeeded. The appeal chambers accepted that we shouldn't have been rejected on the ground of standing. It returned the matter to the first instance, to the pre-trial chamber, and now it is still pending. You would have think that the arrest warrants would have been quashed after that. Simple reasoning, right? If you haven't determined jurisdiction yet, how can you issue valid arrest warrants? We asked for their annulment. What do you think the decision was? Well, no, that's a separate proceedings conducted ex parte. No, the arrest warrants are still there. So I think this is a very, very clear case of a bias. Still, I think we have a very strong legal case. And I'm proud that we make our case before the court. Another example, if, no?
Maybe,
Okay.
maybe just because in the interest of time, and I think we want to cover as much ground as possible, I want to turn to Lord Wolfson. I mean, you know, coming from the UK, certainly a leader on rule of law issues, also internationally, you hear the concerns about the functioning of international tribunals. We heard Gilad. We heard that the president of the International Court of Justice 3 days later becomes the president of Lebanon. We see some of the conduct of the prosecutor of the International Criminal Court. Now, what is your take on what the approach should be generally to these institutions? Some countries, like the United States, take very bold steps of sanctioning these institutions. There are European countries that are willing to accept, perhaps it doesn't, whatever happens in these courts are the beacon of justice, and whatever they do is acceptable. I mean, where do you think thinkers about international law, about international politics, should be on that issue?
Well, thank you very much. I mean, I think you're right at the end of the question when you say thinkers about international law and international politics, because the boundary here between law and politics is almost impossible to identify. Was it von Clausewitz said, war is diplomacy carried on by other means? Well, sometimes international law is diplomacy carried on by other means, and it's intensely, or even war, exactly. It's intensely political. I think one of the problems is, I think Israel, and Israel's not the only country, but Israel especially, I think has had something of a schizophrenic attitude to the United Nations and to international courts and tribunals from the get-go. I mean, if you just think back to the late 1940s, on the one hand, you'll find people who'll say Israel has legal legitimacy because of the 1947 partition vote. On the other hand, you have the successors today of David Ben-Gurion's, shmum, like who cares what the United Nations say? Well, it's difficult to hold both those positions at the same time. But perhaps we do. It seems to me that Israel is not America. Israel is not the United States. Israel cannot, in reality, simply ignore the way these institutions work and the job they do. And I agree absolutely with you. I think you do need to have engagement. But you need to have engagement with your eyes open. And the Lebanese judge is one example. But, I mean, I'm always surprised, and I can understand why, because it's politics, why Israel doesn't make the point which some of us in Britain have made. You cannot find a single case in the international context where the Chinese judge has ruled against the interests of China. I mean, that's because a lot of countries send really politicians to these courts. But you do have to engage. I think it's impossible for Israel on the world stage simply to say we're not turning up. I think you have to turn up. I think you have to present the arguments. I mean, I was disappointed when we were in government, we were going to join Germany and others in protesting the jurisdiction of the ICC. The new government in the UK decided not to do that because they said, we respect the ICC. I mean, I found that an absolutely bizarre statement. I mean, I turn up to the English court on behalf of clients, Mondays, Wednesdays, and Fridays, and argue that the court has got no jurisdiction for a particular reason. That's not disrespecting the court. It's making a jurisdictional submission, which lawyers do. And of course, the reason why the UK took that stance is, again, politics. So, what's running through my comments is you cannot separate, ultimately, law and politics in this area. Every political decision you make ought to have, if possible, a legal background to it, a legal foundation. But every legal decision you make has to be taken within the knowledge of your overall political position. And that, of course, is the challenge. And certainly from the outside, I sometimes worry that in Israel, and you know more about this than I do, there seems often from the outside to be a disconnect between the political leadership and the legal leadership when it comes to responding to these sorts of challenges.
Thank you very much for that, Lord Wolfson, and with apologies to Sharon that I want to get to ask you, a question about what you do. I do want to go back perhaps just for a second to Gilad and maybe to Eran, and to ask about the question of Israel's participation in these proceedings. I mean, we heard from Lord Wolfson that really encourages us to participate and to engage. But Israel hasn't always engaged in these proceedings. The most maybe notable example is the advisory proceedings that Eran highlighted. Israel didn't fully participate. Israel didn't appear in the oral hearings. Can you perhaps shed some light on the considerations that maybe on the inconsistency even in the approach of whether to participate or not? How do you think about this?
Okay, it's complicated. Of course, I'm a bit limited in what I can share, but I can say the process of determining whether to appear or not to appear in a specific case is a very thorough and careful process. As part of the professional echelon, we present our recommendations, of course, as lawyers. Eventually, the decision is always a decision by the political level on a case-by-case basis. Now, the considerations vary. Let's take some of the examples that we mentioned before. So the South Africa case, the genocide case. The case arose, as Eran mentioned, at the very early days of the war. And again, without going into the entire process of the decision, which took place as a matter of hours, of days, very intensive days, because we had very, very little time to respond. The court gave us 2 weeks, to respond. We understood that South Africa's request is for a provisional measure, as Eran mentioned, to halt the war. A unilateral order to halt the war. And we reflected the consequences that might be, if we wouldn't appear and the court wouldn't hear the Israeli side, we would be in a very, very difficult situation. And the mandate that we were given as a lawyers, or the mission, sorry, not the mandate, the mission that we were given was to prevent that from happening. And we succeeded. You saw us twice in the orals, in January 2024 and in May 2024. There are other instances in which we litigated in writings. South Africa tried again and again and again and again to get such an order and failed. We got orders from the court, but these are orders, that Israel can live with. The other issue, which it was, I'm not sure it was part of the mission, but it's part of the way that we saw the mission, was South Africa haven't mentioned Hamas, I think, even once in the case. Eran mentioned the issue of the audience. I think it was extremely important for us to appear there and present the truth. Sometimes the truth has a value of itself regardless of how a court decides. And again, we were in a war, I completely agree. This is part of the war. We couldn't, leave the whole room only for the other side. With regard to the ICC, the situation is much more complicated. I would say that it is entirely reasonable, for Israel to decide not to engage. Again, we're not a state party. After all what I described to you, we can say, no, we will not participate. I'm not sure. It is something that will always need to be considered. As of now, the political directive that we got is, yes, to litigate, at least to some extent. I think, and this is part of the decision, that we have a very, very strong legal argument. Again, I completely agree about the, I'm not naive about the relations between law and politics in that regard, but when you have strong legal arguments, sometimes it also weighs for participation. You asked Roy about the advisory opinion. First of all, you need to note that when you have an advisory opinion proceedings, you have many, many, many states. I think in the last advisory opinion proceedings with regard to UNRWA, we had 40 states, and in addition, international organizations appearing day after day. It takes 4 or 5 days before the court, making the case mostly against Israel. The United States appeared, by the way, so we had, but mostly against Israel. And we decided not to participate in this, prearranged anti-Israel spectacle. To appear there when 40 states, almost all of them argue against you. We have no obligation to appear. We think that the advisory opinions are proceedings that should be rejected by the court right away without providing advisory opinion. I can explain about that later if you wish. But if you are interested, I know it's much less accessible maybe, but we did in February 2025 and in August 2025, we submitted to the court as part of the UNRWA proceedings 2 quite detailed documents, again, setting the truth. The truth about UNRWA, the truth about how we interpret international law in that regard. This is there. Unfortunately, the court completely, or almost completely, almost all the judges disregarded these submissions. But yes, you can count that as partial participation. Again, not in this circus in the whole room, but we do put before the court our positions.
Well, this is fascinating, and there are so many follow-up questions that I would want to ask about it, and I may ask them later on, but I do want maybe to come to the issue of international justice from a different angle. And I want here Sharon to invite you to tell us. Sharon is the director of the Dinah project. She will tell us about it in a minute. I do want to, but maybe I should say it deals with justice to victims of sexual assaults in October 7, but maybe even more generally. And here maybe international justice can serve a different purpose. We're discussing it now all the time as we're defending against these proceedings, but maybe there is something also to gain from this. So perhaps just for the benefit of everyone here, you can tell us a little bit first about the project itself and what you're aiming to achieve, and maybe elaborate a little bit about your thinking, how this project can interact with our discussion about international justice.
I think I'll start first by connecting to what my esteemed colleagues just said. First of all, I think that we are an organization, an NGO, and we are also sailing in these murky waters in the world globally and in the UN, because the UN is a very complicated organization, very complicated relationship with Israel, but also the UN has different organizations and bodies within the UN. And we saw, regarding the sexual violence that was perpetrated in October 7 and captivity, that the first global recognition by the world was by the UN, by the Undersecretary of the Secretary General of the UN, Pramila Patten, that came to Israel to a fact-finding mission, and she was in Israel for 2 months, and it was the first recognition of sexual violence in October 7 and captivity. And later on this week, we saw from Rima Salem, which is the rapporteur that is responsible for violence against women and girls, and she claimed that there was no formal proof of sexual violence in October 7 and captivity. And we see the difference, and we have to navigate, because if we seek for justice and recognition, we have to understand that the world is layered, and we have to navigate in different arenas, and to choose our battles, and sometimes to ignore, sometimes to fight, and sometimes to collaborate with entities that can get to our goals. So this is my first remark. And the second remark regarding the claim against Israel in the ICJ by South Africa, and the claim and the fact that Hamas was not mentioned there. And I think this is one of the main goals that we put to ourselves, and I will speak in a minute about us and what we do in general, but one of the things that is most important for us is to bring the truth out and to prove what happened and to create a base that proves that sexual violence was perpetrated in October 7 and captivity. And we think that this can have a very important part in Israel defense in the ICJ. Of course, we know that chances are slim. We heard why, but I think the truth needs to be said, not only about everything that happened in October 7, but also regarding the sexual violence. And we, the Dinah Project, is named, sometimes people ask me, I think in this audience, all of you or most of you know who was Dinah. Dinah is the biblical daughter of Jacob, the first recorded story in the Bible of a woman that was kidnapped and raped, and she didn't have a voice. And us in the project, we try to bring this voice of victims and survivors of sexual violence, as I said, in October 7 and captivity, but also we try to study and to learn from what happened in October 7 regarding the sexual violence to other arenas around the world, because sexual violence as a weapon of war, which is a crime against humanity, is not a phenomenon that was unique just to Israel. It's not something that started in Israel. It's something that is known from the dawn of humanity. But if we look at other arenas, we see that there are seldom indictments. Seldom we find perpetrators get accountability, and most of the times they get impunity. So we try to study from what happened to other arenas. We have a universal message that we want to convey. And we aim, our main goals are to get recognition and justice for victims and survivors of the sexual violence that happened in October 7 in captivity. And we, sometimes people mistake us for other groups or other organizations. So first of all, I have to say that we are not a government. We're not a governmental organization. We're not funded by the government. We're a small organization, independent of researchers. We're under the auspices of the Rachman Center and the Bar-Ilan University Faculty of Law. We are independent researchers, and I think it helps us to convey our message because when we come and we present our doctrines and our facts, then people tend, of course there's always suspicious, people tend to listen because we are not coming from the government. And we are, I and the other members of the group, we give briefings and lectures in many places in Israel and around the world to diplomats, to scholars, to reporters, and they do tend to listen more. And in that regard, although there is problems in the international arena, we have the, I wouldn't say the luxury, but we can choose our battles more freely. And another thing I wanted to say is that we are not an archive. We're not documenting evidence. There is an ongoing investigation in Israel by the police ever since October 7 regarding what happened in October 7 and also the sexual violence. And because some of us are lawyers from the criminal law world, then we know that we do not want to impede the investigation. So what we do is monitor every open source information, and we built a platform that analyzed all the open source information that we gathered. Of course, we also get people that come to us, but we analyze all the information, and we try to cross-reference and check every item of information. And because we come from the criminal perspective, then we are very strict in the way we look at things. And in our matrix of information, we do not include information that we know that has problems, legal problems. Because we know from the media that there were some admissions by terrorists of using sexual violence in October 7, but I didn't see the whole testimony, and we know there is a challenge regarding testimony that is given to security forces. So we did not rely on that information, although it exists. We relied only on information that we can count in order to create a strong and robust base of information regarding October 7. So we monitored and analyzed and wrote a report regarding all the sexual, it's the most comprehensive report regarding all the sexual violence phenomena that happened in October 7 and captivity, which we view as a continuum. And the second thing that we do, and maybe I will elaborate it a little bit later, is trying to build a roadmap, because as I said, there is seldom indictments. There is almost no accountability. And we analyze the challenges of conflict-related sexual violence and try to write a roadmap for prosecutors, but also for other proceedings in order to get accountability. And we built legal doctrines in order to help to get accountability. And in July, we published this book. It's called The Quest for Justice, October 7 and Beyond. And Beyond is the international and universal perspective of our work. And we also built a website that is supposed to be a hub for all the information regarding sexual violence that was perpetrated in October 7 and captivity, but also for other arenas. And what we try to do, and I think it's also has an expression in this book, we try to use accessible, creative vision in order to make this terrible and difficult information, which people don't want to hear about, we try to make it more accessible for the public. So this is our true aim.
Well, thank you very much for that. And I want to turn to you, Lord Wolfson. You're a leading member of the bar, and I have an opportunity to ask for some free advice, so I'm not going to give up on it. But maybe to try and benefit from your somewhat more external perspective. I listen to my colleagues here, and you see the strong conviction of we're telling the truth. We will share the facts. We will engage. We try, and still I remain with a slight sense that we don't always succeed to convince everyone, and maybe we don't. It's very difficult for us to convince people around the world. So, obviously maybe it's their fault, but maybe we're also not perfect. Maybe we're not doing everything that we can, or maybe we can do some things better. When you're looking at us from where you sit, what kind of advice can you give us? What can we do? What can these people do? What can we as a country do better that may help us make our case in a more robust and maybe more convincing way?
Well, that is a huge question. I'm tempted to say, the old thing about the difference between a good lawyer and a great lawyer is that a good lawyer knows the law, but a great lawyer knows the judge. And of course, one of the problems is, as you said, when you started, your introductions, that one of the problems is that we know often who the judges are. And so you do feel sometimes that Israel is starting a game, sort of 1-0 down, that the scales are not balanced. In the real world, I think that can't really affect your approach. You still have to continue and carry on. I do wonder if you ask me what could Israel do, well, I don't know whether Israel doesn't do it. I suspect Israel does do it. Perhaps what I'm really saying, that Israel should do it more openly, is that there is, I think, a mood out there in quite a number of countries, more than countries who say this on the record, that there are problems with international institutions. I mean, we're focusing on the ICJ and the ICC. In the European context, and this is a different political issue, but the fundamental legal issue is the same, with the Strasbourg Human Rights Court. There is, I think, a mood out there that the post-World War II settlement, legal settlement, needs revision. And although Israel is a small country, it is actually disproportionately involved in a lot of these legal issues. And I would like to see Israel do even more, and I use my words carefully because I'm sure it does happen, but do even more to build a coalition of countries who are signed up to the idea of international justice, who are not renegades like, Russia or Belarus, but who believe that the 2025 world is not the 1945 world. I mean, to make the point, which you were making, a lot of these procedures and conventions and jurisdictions are premised on state v. state battles. What Israel faces is a state actor against a non-state actor. And the truth is that the system isn't really geared up for that. I mean, that's why Hamas is not mentioned by South Africa, South Africa would say, in their application to the ICJ. And of course, they don't want to mention Hamas because they don't want to get into what Hamas did. I appreciate that, I'm not naive. But they will say, as a matter of law, well, Israel is the subject and Hamas is not. I think there is a mood out there, and I would want to see Israel building on it and perhaps even leading it, to reform institutions, but so to speak, from the inside. And I would not underestimate how many countries might actually be amenable to that. So that's a more positive note, perhaps, for our discussion.
Well, I'm sorry. We're not opening it. I'm sorry. I'm sorry. No, we're not opening this to comments. There are many people here in the audience that would want to make comments. I'm sure, but this is not the format. After the after the event, we can have the discussions. Eran, I want to turn to you and maybe around the same point. You were part, as you mentioned, of the team defending Israel in the International Court of Justice. Were there moments that you felt difficulty? What did you feel were the most difficult challenges in defending? It's a preposterous case, a case on genocide. What did you feel any difficulty at all, or what was your sense of the type of issues that might have been more complicated?
Well, we've been sitting here and complaining about the international legal system, and that's okay. We're a bunch of Jews, and we're in Poland, so that's part of our identity, I think. But but I want to also perhaps use your question to point the finger not outside, but perhaps inside. I'm no longer with the government, so I can say whatever I want. And the IGL is practically a mishpuche, so let's keep it within the mishpuche. But I think there is a lot, having said about all the problems with the international legal system, I think there is a lot Israel also, could do better, at least be able to make a better case at the international level. So, for instance, one of the challenges that we were facing at the hearing in The Hague and still are, is that in order to establish a genocide, the violation of the prohibition on genocide, you need to establish that there was an intent. Okay, so intent is a big thing. Sometimes the same acts could mean different offenses depending on the intention. And in order for the South Africans to establish their claim for intent, they were obviously basing themselves on many statements made by Israeli politicians and state leaders. And to be honest, again, within our own mishpuche, some of these statements are repugnant and are very hard to defend. And we were finding ourselves, trying to explain to the court, well, this statement made by our heritage minister that Israel should just nuke Gaza, well, he's on our government, but he's outside the decision-making processes, right? It seems sometimes, the world is taking our government sometimes more serious than we do, but what do you do if some of these statements were made by people who are sitting at the war cabinet and are relevant people in the decision-making processes? So I think that's a very challenging issue. It's a war, I could accept that sometimes there's war rhetoric, and it's something we've seen in other arenas, but I would expect at least our leaders to be cognizant of the special, unique challenges that Israel is facing, and also to conduct themselves otherwise. And I'm putting aside, some of them are just, I think morally and ethically such statements and intentions should be avoided. And sometimes, if there are, one of the accounts under the Genocide Convention is incitement to genocide. So sometimes speech itself could be a violation of the Genocide Convention. And there, I think, sometimes investigating and taking account is also important. In addition, there is also conduct, okay? We have seen on media outlets around the world how some Israelis are just vandalizing humanitarian convoys to Gaza, and sometimes it seems like Israeli police, is just standing from the side, and people are also hearing, what perhaps some of these, maybe instructing them to do so. And the ICJ, it did not evade the ICJ, so the ICJ refers to this, and they're saying, well, something is happening there, so we can't take what you're saying at face value. And I don't think that Israel is using starvation as a method of warfare. I would be clear about that. But sometimes we're just, making it too easy, for others to criticize us. I already mentioned, many videos released by IDF soldiers. There are thousands of them, and I'm sure most of them, they don't raise really any suspicion, but sometimes they could raise questions. And another insight I had, throughout this war, Ben, myself, our duty for the first month of the war, and when we were on reserve service, was to provide legal briefings to government officials, military officials all around the world. And at some point, we realized that we're coming to brief about the situation in Gaza, and we are faced with questions about what's happening in the West Bank, okay? And I remind ourselves that at the beginning of the war, and still are, there are reports of, significant violence taking place in the West Bank. Sometimes, some things that they conduct that reminds pogroms by Israelis living there. And I realized that what's happening, we're dealing with Gaza, but what's happening in a different arena in the West Bank casts a huge shadow on what's happening in Gaza. And when some are around the world are assessing Israeli conduct and intentions in Gaza, they are doing this through the lens of what Israel is doing or allows others to do in the West Bank. So that's also something we need to take in mind. And I think Israel should just conduct itself morally, ethically. That's obviously, but also be acknowledging that if not by not doing so, it also has ramifications overseas.
And also, just yeah. I mean, I absolutely agree. And also on the ICJ, I mean, what many of us didn't understand outside Israel is why Israel didn't set up a judicial commission, which would then immediately adjourn, so to speak, until the war had ended. But it would enable you to say to the ICC, we have a judicial commission looking into this under the principle of complementarity. But, if you leave that space open, and we can put the judicial reforms to one side for the moment, but of course they're relevant, but if you don't do it yourself, you leave the space open for the ICC. And I know a number of us outside Israel were mystified on a legal basis. We understood politically. But on a legal basis, we were mystified as to why Israel didn't do that.
Yes, and so maybe Gilad, it calls to pass the question in some way to you. Now, I don't want to put you in a position that you need to comment not on statements of Israeli politicians and not on big policy issues. I do want to ask you, from your experience, to what extent to what extent the strength of the Israeli legal system, its independence, the the role of the Supreme Court, the independent role of the Attorney General and the Military Advocate General in pursuing, criminal proceedings in appropriate cases. To what extent does this play a role in the international proceedings, in legal arguments that we make before the International Criminal Court, before some of the other institutions? Is it important? Are people interested in that, or it's it's not really a significant issue?
So my answer to that is very clear, Roy. Yes, it is very much significant, and we know that. We know that for many, many years. We proudly presented our legal system in many instances in foreign proceedings. I said these things in the Knesset, by the way, at the beginning of 2023, when the reform began, and I was asked about that. And I said this is significant. I didn't opine on particular, measures that were considered. When I stood before the ICJ, I also stated and committed, myself, even personally, as part of Israel as a rule of law state. I can, I have some quotes here. You asked specifically about the Supreme Court. That's a quote from things I said to the court. At all times, the door to Israel's courts, including Israel's Supreme Court, remain open. The court is widely acknowledged for its willingness to consider issues pertaining to the conduct of hostilities, including ongoing hostilities. Indeed, during the current conflict, I spoke about October 7th, the court has already considered petitions on different aspects of the war. Now we can say, 2 years afterwards, yes, there are quite a few important cases before the Supreme Court, and yes, it is meaningful. And to that, I should add, there's a whole argument. Well, to what extent does that assist us? I'm not sure. Yes, it assists us. My answer is quite clear about that. But regardless of the international perspective, I think commitment to the rule of law, commitment to democratic values, in its deepest sense, that's an ethical imperative at the highest order. We should treat that as such. When I stand before the ICJ or any other international forum, I don't merely represent, the state of Israel as a slogan. I represent a whole set of values of Israel as a Jewish and democratic state. At the basis, at the core of that, is the commitment to the rule of law. As an international lawyer, I am proud of the Supreme Court. It has dealt with extremely complicated dilemmas. It has done so courageously, with a thorough, commitment to these values, even during the war. And I think we should keep that.
Maybe just for the benefit of the audience, a word about the principle of complementarity and the role it plays in international institutions. Some people that are more involved in international justice may be familiar, but maybe not everyone. So, just very briefly to sketch that division of labor between international and national courts.
Okay, that was the subject of my doctoral thesis some years ago, and it's, of course, subject to debates and interpretation. Again, at the core, complementarity means that international institutions, international judicial institutions, should refrain from intervening when things are being dealt with at the domestic level. I think that the rationale behind us are that, local judges and local judicial system are much better equipped, to deal, and we know that as Israelis. We know the complexities of the conflict. We know the complexities of the legal issues. We see how our Supreme Court and how we deal with these issues, balancing the various interests and the complicated national security issues that we are dealing with. We are much better equipped than any international court to do so. This is why we think that what the ICC has done, and again, the complementary principle is a fundamental principle guiding the ICC. The ICC is complementary to national criminal jurisdiction. And again, I think regardless of the fact of what Israel actually did, when we are dealing with the rule of law democracy, the court should have looked at it as such. And maybe I'll say something more general. I know you haven't asked about that, Roy, but the court today, the ICC today, I think as Lord Wolfson mentioned more generally international judicial institutions, they are in a crossroad now. There's a huge question mark about all kinds of various issues. And now the ICC, is also standing in such a crossroad, not only with regard to Israel. When we present our legal claims before such institutions, it is also an opportunity for the institution, to say, well, yes, maybe there is something there. Maybe we should take a different approach, which is the approach upon which the court was established. Let these kind of states deal with their own issues. Let's focus on the really troubling issues in which you must have an international criminal court to deal with. That's the essence of complementarity.
Maybe Eran, you want to add something on the...
Yeah, so Gilad mentioned the principle of complementarity, as a principle, organizing principle between the domestic courts and jurisdictions and the court. Let me give you also the practice of this issue. I've attended many sessions, over my years in the military when a state was considering whether to launch a criminal investigation into an incident that involved IDF soldiers, or they were assessing Israeli conduct to decide whether to allow the sales of arms to Israel. And the first opening lines, in practice, were always our legal system, how we provide legal advice to Israeli authorities, both on the military level and the government level, how we investigate and press charges when necessary, and how the system is independent and professional and effective in what it's doing. This is practically the shield. And it's not just, formally, right? It's not, complementarity is a formal principle. It's relevant primarily in the relations between states and the ICC. But even informally, there's like a halo of the Israeli legal system that when you engage with other jurisdictions, with other law enforcement bodies, they appreciate if you have something to present. And I think that we are having challenges today, okay? First of all, we hear what some of the Israelis and Israeli leaders are saying about our own legal system, right? That it's corrupt, that it's independent, it's ineffective. So if we don't trust our legal systems, how could we expect others to do so, right? And we are also witnessing attempts to weaken the independence of the Israeli legal system. The Attorney General, the Military Advocate General, the court itself. We always took pride that even when the IDF is making a decision subject to legal advice, then there are also, two layers of civilian oversight. One is the Attorney General, and then there's also the Supreme Court. But there are attempts to weaken these very same bodies. And also, we've seen it quite intensively in the context of the current war, a growing objection, both within politicians, but also in broader allies of society, to the idea of investigating and holding accountable those who are suspected of violating the law. And some of you may recall, the images, the horrific images of mob led by Israeli politicians storming into IDF bases because the military police came in order to question, just to investigate serious allegations against IDF soldiers for abusing a detainee there. And we see that there is a sentiment in the society and a sentiment and strong convictions among some of the decision makers. And I think it reflects very poorly on how others might also see our system. Lord Wolfson mentioned the fact, that, sometimes the allegations against Israel are touching the very core policies of the government. Here, for instance, a national commission of inquiry could be the right tool to investigate and maybe to confirm the legality of Israeli policies, but it hasn't happened yet. And I do hope, that all these would not have, but there is such risk of some kind of a chilling effect, on the Israeli court and on other Israeli legal instances. And I think we should be very, very cognizant of the risks that this may present, not just, I think, to our, identity within Israel, but also to the risks overseas.
Sharon, I want to turn to you, and admittedly we didn't plan this, so if you feel less comfortable discussing this, that's it's absolutely fine. But I want to draw a little bit on your experience as a former chief military prosecutor, and you had to deal with some very sensitive cases of allegations relating to misconduct, sometimes very serious misconduct of Israeli soldiers. Do you believe do we have an independent prosecution? Do you believe that the IDF is capable of making these investigations? Do you feel that these issues are better investigated by international courts, or maybe better investigated by our own prosecution service? Again, to the extent that you feel comfortable sharing.
It's a tough question because we know.
Yeah,
it's a tough question because we know what has been going on in the last few weeks, and of course it hinders a lot of the occupation in the subject. But I can only speak from my experience in the army. At the time that I was chief military prosecutor, I was a prosecutor for over 24 years. Chief military prosecutors, that was my last position. I retired about 7 years ago. And from my experience, and I was the commander of course, in the military advocate general, there is a special unit that prosecute operative criminal law, from the understanding that criminal law is different from operative criminal law. And this unit was really very professional and excellent. And I can only say from my experience regarding incidents of soldiers that were committed crimes or misconducted, or I engaged with the case of Elor Azaria, which is a very famous case. It was, I think, a little bit of the beginning of what we're seeing now. But from my experience...
Just for the benefit of the audience, a little bit maybe about the Elor Azaria case.
I think yesterday, Dinah mentioned it in her panel. Elor Azaria was a soldier. It was in 2016, and he was a soldier that there was a terror attack, and the terrorist was neutralized, and he came to the scene of the attack about 8 minutes after the attack. He was a medic, and 11 minutes after the terrorist was neutralized, he shot the terrorist and killed the terrorist. And immediately there was an investigation by the military police, and later on there was an indictment by the prosecution in the army, and it was a very controversial case in Israel because it was the beginning of the mix between criminal, clean proceedings and political influence, and there were a lot of protests. And I think that what protected us back then, that we really adhered to the law, to the interpretation of the law, and to the evidence. And when we focused on the law and what was obligated from us by the analyzing of evidence and so on, then we felt safe that all of the noise, and there was noise, all of the noise was above our heads. We tried to ignore it. It was very difficult. There were threats on the prosecutor. There were threats on the main judge. There was also some threats on us. If we equalize it to what is happening now, it's very different. It was in a smaller scale. But my experience from that is we didn't deter from prosecuting. We didn't, even if there was a lot of buzz and a lot of controversy and a lot of protest, And also from my experience, every time there was a claim regarding misconduct of a soldier or any other claim against a soldier in his position as an operative, as a combatant, then we investigated it, even if we didn't have a complaint. There was sometimes that we saw an article in the newspaper, and we did a preliminary investigation, and then if there were ample evidence, we continued with the evidence. I am hoping that now with the new military advocate general, regarding what is happening in the army, they will continue to investigate. There were some claims in the last 2 years that there was not enough investigation regarding what happened. Eran talked about Sde Teiman, which is now, of course, very controversial, but it was a good example that the military police investigated and there was prosecution and the case was ongoing. What is going to happen with this case, I don't know by now.
Well, I think we should all be very grateful that we have such courageous and independent leaders of, of our prosecution service. And thank you for, sharing this experience. I want to ask you, Gilad, we have a few minutes left. To what extent, I mean, you're in a position that you actually engage with senior politicians, with the government, with the cabinet. To what extent the issue of, there are risks involved in these processes in the international arena. We see, whether justified or not, we see different countries taking measures against, our leadership, against the IDF. To what extent is the issue of, international tribunals, international law? To what extent is it present in the considerations of our leadership in developing policy and thinking about, what to do or what not to do?
Well, I can only comment on that, from my perspective as a professional, as a lawyer. So, first I can say that it is our, professional responsibility to reflect, what is happening and what is being decided in various international judicial bodies. So from a pure professional perspective, we always conduct, an in-depth analysis. We learn the decisions. We put aside for a minute the question, yes, we agree with that, we don't agree with that, we are angry about the decision, which is quite often the case. And we try, to learn, to read what they write, to see what kind of interpretations of international law were adopted. In certain cases, it may make us, reassess our own interpretations. Although we should note that, we provide our legal advice according to what we view as professionals as the situation according to international law and what kind of interpretations Israel should adopt. But, we cannot avoid this world of international courts and the interpretations that are adopted, and it is part of our work. Now, one of the problems is that many of these decisions do not really, or the judges, they don't really grasp the complexities, the challenges that Israel is really facing, really dealing with. This again goes to the previous question. I think our Supreme Court, our system, our professional lawyers can do it much better. So what we need to reflect, to the political level, is on the one hand, the interpretations of international law and, the judgments and the various decisions that are being made, while, again, bringing into the room also our experience as Israeli lawyers, bearing in mind that international law is always applied in a particular context. This is true not only for Israel, I guess any legal advisor around the world is doing the same, and Israel has its unique, of course, national security interests. So the bottom line is it's always a matter of weight, you know, and to what extent interpretations of international law or trends that we see in international tribunals should be considered in a particular context. That's the most I can say.
Well, thank you very much. I mean, we're coming to the close of this session that I must say was, at least to my mind, really a fascinating session in terms of the issues that were raised, and even the willingness of participants to go even a bit further than usual in some of the comments. I would like to end giving each one of you, if you want, an opportunity, just in one sentence or two, just one thought that you maybe want to share with us in conclusion of this panel. Maybe something, if possible, a bit more positive, more encouraging. Anyone? Any thoughts? Any ideas? I mean, I would like to say, I will say one thing. I think Israel is a country where the idea of the rule of law is very strong, and the basis of our democracy is very solid, and we see it with the involvement of the Israeli public in public debate and in political life. And I think that with all the very terrible things that happened to us after October 7, I think in some way it also brought many of us to, notwithstanding the political differences, highlighted how much unity exists. So, I think that, at the end of the day, putting politics aside, there is a very strong people there with a foundation based on very strong ground. So I'm very optimistic for the future. But maybe...
Yeah, thank you, Roy. I see... I'm afraid I do see many concerned faces in the audience, because over the hour and a half we kind of painted a very dire picture, of the world. And Meir mentioned yesterday that all the Israeli song of the world is all against us. But fear no more. When you leave the room, I want you to leave the room very optimistic, because we have a secret weapon. We have a secret weapon in Israel, and I want to share this with you. Can you put the slide on? Listen, these pictures were taken at the Israeli embassy in The Hague in January last year, when we were there for the first hearing before the International Court of Justice. And what you see here, you see Tammy, the legal advisor of the Foreign Office for the past 25 years. You see the legal advisor for the National Security Council. You see people working at the Attorney General's office. And the thing is that in addition to pleading our case orally before the court, there was also a procedural way that we could submit also documents. And we wanted to submit many, many documents. We had a lot to say. It was around 450, I think, documents. But according to the procedural rules, you had to submit in 30 copies, okay? 30 copies. Now imagine, 450 documents, 30 copies of binders. So this was like a serious test. We were trying to calculate how fast the Xerox machine are working, and we need to put binders. Now, when it was 4 o'clock in the morning, it didn't matter whether you work for the Foreign Office and you're a distinguished lawyer, or whether you're a colonel in the military or whatever. We knew that we're working in the service of the State of Israel, working in the service of Am Yisrael. And when you know that this is the motivation, you do whatever you need to do. You lie on the floor, you put binders, you schlep the binders. That's better be around, I think, 7 a.m. already in the morning. You schlep the binders to the car waiting downstairs to take it to the embassy. And that's, I think, really the secret weapon in Israel. The excellent, really, I'm no longer there, so I could say this, the excellent people in the public legal service of the State of Israel. Okay? Sometimes, sometimes when you're reading the news in Israel, these people are tarnished and criticized, but they're excellent. And they're so excellent, not just professionally, but also because they know that they're working for a very, very good cause. I mean, this was part of my Zionist mission, and I think it's a part of everybody working in the public legal service, and we should make sure it remains this way.
Thank you. Thank you very much. So, this panel is coming to a close. So I will be grateful if you join me in thanking our excellent panelists. And thank you all.